Well, if the government believes that by fast-tracking changes to anti-rape laws, by using the route of the ordinance, they would actually incur public goodwill, they may have been in for a bit of a surprise. The initial reactions coming in from those groups who have been fighting for changes to the anti-rape laws has been that of skepticism, even anger. To defend the government's decision and to explain the rationale behind it, I'm joined exclusively by Law Minister Ashwani Kumar, who joins me from Punjab, where he is at the moment. Thank you very much indeed, sir, for joining us. Now, Mr. Kumar, no one would have a quarrel with a government that wants to fast-track decisions, especially when it comes to something as sensitive and emotive as these anti-rape laws. But the voices of those who've been asking for change seem to suggest a degree of surprise. They believe that the entire process of bringing these changes through the Justice Verma Commission was deliberative. It was a long, drawn-out process. Why did you try to push through this ordinance in such haste?
Well, quite clearly, we are responsible to the people of India to validate the promises and assurances that the UPA leadership gave to them in the aftermath of the gruesome tragedy of Delhi. We had assured the nation that there would be no delay in bringing in a purposive, credible and progressive legislation after we have received the considered recommendations of the JS Verma Committee. We acted with the utmost expedition and gave at the same time our thoughtful consideration to the recommendations of the Verma Committee. We believe that we have done justice to the recommendations. We have brought in a law which, generally speaking, is well considered, comprehensive, and will go a long way to assuage the feeling of insecurity amongst women.
But
having said that,
yes,
let me hasten to add that all lawmaking is an ongoing process. We are always open to any suggestions at any point of time to make the law even more purposive. We decided the way we did because we thought it subserved the substance and the spirit of the laws and the requirements of the day, and that we had responded positively to the felt sensitivities of the people at large. We are open to persuasion at any point of time.
Okay.
And
no, I think your assurance that this is
the law.
Okay. Yeah, I think your assurance that this is a continuous process is something that would be welcomed. But at the same time, questions will be asked about why you chose to retain certain recommendations of Justice Verma and omit others. Now, many of these groups believe that you've rejected the most substantial suggestions and the spirit of Justice Verma's recommendations, which proposed radical changes in the anti-rape laws. Would you agree?
Not at all. In fact, we have accepted 90% of Justice Verma's recommendations. It may be a difference in perception or interpretation, but let me tell you, we have actually responded with the utmost sensitivity to the recommendations of Justice Verma, because we do appreciate and we know that a lot of effort had gone into proposing those recommendations. But at the end of the day, government is entitled in its wisdom to take a holistic view of the entire gamut of issues involved. And if we have not accepted 1, 2, 3 or 4 recommendations, there are good reasons for those, and those have to be in any case addressed in some other laws which are not the subject matter of what was being considered by the Standing Committee of Parliament. The Criminal Laws Amendment Ordinance and the changes in the IPC could be clubbed together, but other specific legislations have to be dealt with entirely on their own.
But Mr. Kumar, in fact, many of the recommendations which you've accepted also come under the Criminal Law Amendment Bill. And this is the argument that these groups are making, that the sections you've accepted which have to do with the definition of sexual assault, or to bring in things like acid attacks, voyeurism, stalking and all of that, they say would have anyway happened as a matter of course under the Criminal Law Amendment Bill. And therefore, what is the new and substantial change that you brought with this ordinance?
I think you misunderstood what I was saying. I said most of the changes that could have been brought in the Criminal Laws Amendment Ordinance and the IPC have in fact been brought about in this composite ordinance. This ordinance contains not only those provisions which were the subject matter of discussions by the Standing Committee under the original Criminal Laws Amendment Ordinance, but it also includes Justice J.S. Verma's recommendations, and together we have vastly expanded the remit of the Criminal Laws Amendment Ordinance, which has now been decided to be requested to the President to promulgate.
It's interesting you say that, because these groups believe the exact opposite. They say that the most radical aspects of Justice Verma's recommendations, which included tackling the institutionalized impunity against women when it came to sexual violence, has been omitted. Primary amongst that is that you've left out marital rape without giving any clear reasons. It just simply says, was not retained by Ministry of Home Affairs as marital rape was not agreed to. Why was that omitted?
Please read the new ordinance and its provisions in its entirety. Sexual assault of any kind, which will include any situation, is not outside the remit of this Act. Therefore, this is a matter of subjective interpretation. And in any case, if any clarification is required
a matter of interpretation
in any particular provision, that can always be done.
It says very specifically, I have the press release yesterday of the government before me. Under the not accepted column, it very clearly says, sexual assault by husband upon his wife during separation. Verma committee wanted to include it, but marital rape was not agreed to. So you've clearly excluded that, for at least in the ambit of this ordinance.
Now look, I cannot define the ambit of the ordinance with reference to a communique. I don't know how you are reading it. But I want to assure you that no case of sexual assault is in a way outside the remit of this ordinance. Sexual assault has been very, very widely defined. And this is not the place for me to discuss the nitty-gritty of a particular provision. I will not be doing justice either to the provision or to the debate.
Okay, but this particular provision, because there's so much, it's triggered. Are you saying, therefore, that the definition of sexual assault as per the original ordinance, a copy of which we don't have, we only have your press release, is wide enough to include rape within a marriage? Marital rape would be included in that wide definition?
The problem of discussions of this kind is that you don't have the ordinance in front of you, and you are seeking to present a point on the basis of some communique that has been issued.
No, but that's why I'm asking you, sir.
I am telling you, and I've stated it twice, that sexual assault as defined in the ordinance is as wide as it could be to subserve the purposes of the Act.
Okay, the other area which they feel, which again feeds into their view of how you've not tackled the question of impunity, is where Justice Verma had recommended that there should be responsibility fixed, what he called command responsibility of those who are in any position of authority, as well as public servants, bureaucrats, and of course the armed forces. In each of the cases, he'd wanted to bring them under the ambit of the anti-rape legislation, that there was no need for sanction, but you've excluded all those authorities. Why is that?
Well, what we have stated is a part of the ordinance that we have proposed to the President to promulgate.
Yes.
I started by saying that if certain recommendations have not been accepted in their totality and in the form that was suggested to us, that has been a conscious and a deliberative decision. Government is entitled to take a view considering the totality of the circumstances and the exigencies of administration and a whole range of other issues. But suffice it to say that no one can accuse the government of not very, very substantially accepting the letter, the substance and the spirit of the Justice J.S. Verma Committee's recommendation.
This is a process, this is a democratic process. Could you share, while of course the government is entitled in its wisdom to retain what it wants and reject what it wants, but if you could help us by sharing some of that rationale, because that's what people want to know. For example, you have rejected the idea of sanction for prosecution for judges, magistrates and other public servants because you believe that this leads to false complaints. Was that the concern there? Yeah, that's what the ordinance says.
Yes. Well, this is always been one of the concerns, that you have to protect people from vexatious prosecution. This has been the logic in the Lokpal bill. This could be the logic here. But there are a whole range of issues. For example, command responsibility is a matter that has to be considered in its totality. Therefore, please understand what was the immediate need. The immediate need of the hour was to secure and send out a clear message to the women of this country that they have no reason to feel unprotected and insecure against mindless violence and heinous crimes against their person. I think we have more than fulfilled and validated that assurance to the people of India.
So are you saying, sir, are you saying, Mr. Kumar,
in a
is it correct?
Discussion, in a 3-minute discussion, please don't expect me to convince you or anybody else about the exact intent and the letter
we're
of the law that is a
extending
part
this
of the
discussion.
ordinance.
It's much more than 3 minutes. Is it correct for me then to interpret from what you're saying that many of these areas which you earmarked as contentious and therefore have left out, whether it's to do with marital rape or sanction to prosecute those in public authority, AFSPA and so on, you're not saying that you've completely ruled out the possibility that they could be brought in through some later form, in the form of the legislation, the Criminal Amendment Bill, for example, or through other routes that are available before the government. You're saying this is just the first step. Is that correct?
No, I'm neither saying it is a first step, nor am I saying it is a second step. All I'm saying is that lawmaking is a dynamic process. The ordinance occupies the field until it becomes an act of parliament. In the process of the ordinance becoming an act of parliament, the honourable members of both houses of parliament will doubtless express their views, and in case the government is persuaded to delete or add any provision itself, it can do so, or the House can decide in its wisdom whatever it wants to do. There is never a final word in any law. Laws are subject to reappreciation, they are subject to review, they are subject to amendment. And if we do find that we have left out something that should have been in the ordinance, I have no doubt that, consistent with the sensitivities of the of Parliament and the people of India, government will be very happy to review what needs to be done.
Okay, can I just ask you in conclusion, because one of the recommendations you've made is to recommend the death penalty in the rarest of rare cases of rape. This was actually something which is outside the ambit of the Justice Verma committee, which didn't in fact recommend the death penalty. Could you share with us the thinking behind that decision? Because that's quite a major decision.
Well, it is quite let me tell you what we have stated. We have stated, where rape is followed by killing or murder, the minimum punishment will be 20 years, extendable to life, which would mean the natural life of a person, or we have given an option, or death. Please remember that the Supreme Court of India and the High Courts even now have, in appropriate cases, treating them as rarest of rare cases, awarded capital punishment in similar cases.
Yes, that
what the
already
Supreme
happened.
Court has been doing thus far, we have now brought it as part of the statute and given it statutory recognition, so as to give out a feeling that we will proceed with utmost stringency as a matter of law to punish those who violate and kill women. This has been the central message of the legislation. It is not necessary for the judge to award the capital punishment. So there is nothing inconsistent between what we have said and Justice J.S. Verma.
All right, Mr. Kumar, thanks very much indeed for coming forward and explaining the rationale behind the ordinance, and also defending some fairly strong criticism of it, some groups even going so far as to call it a betrayal of their public campaign and the activism of all these months. But you, of course, would hold otherwise. Thanks very much indeed for joining us, Mr. Kumar.
India's #1 news app. just got even better. Download NDTV's new app. Fully optimized for Retina display. Full screen view. Faster response time. And Sudoku. NDTV's new iPad app. Download now.